let's jump into it. So we've all heard the stories. You may have seen when you came in the streaming news stories. Harvey Weinstein, Matt Lauer, Russell Simmons. Typically the story is about a very powerful man who is coming on to a less powerful female. But we all know that there's more to it than that. There are way more stories than what you see in the media. And we're going to talk about some of those issues today. Men experience sexual harassment as the victims, of course. The sexual harassers are not always men. They're female sexual harassers, and we'll talk about that. There are also incidents of false claims, where people have reported sexual harassment and it may not be the case. So we'll talk about those issues. We also have joining us someone from the EEOC who will give the EEOC's perspective on the sexual harassment issues too in this Me Too era. And then we will end with some tips for employers. How do employers best minimize the risk of sexual harassment claims? These are the folks who will be presenting to you today. These are members of the ELS team. Daryl Graham with the EEOC. These are the people who will show up today. But I should tell you, though, we are also these people. So you may get a little bit of that going today, too. Now, notice that the EEOC is still the EEOC, right? No matter what, the EEOC is the EEOC. Let me acknowledge some folks in our audience today, too, because we have a very mixed audience today. We advertise to the lawyers as this is a CLE, and this is CLE season for us, so that's good. There will be CLE credit available, but we also have HR professionals in the room. We have business people, business owners in the room as well, so we hope that that will lead to a rich discussion. We also have plaintiffs' employment lawyers that have infiltrated today, and so the plaintiffs' lawyers will help shape our perspective on some of these issues, too, because they come at it from a far different perspective than we do as primarily defense attorneys. Speaking of that, in your packet of materials, I hope everyone has a packet, there at the end there are bios of all of the people who will be speaking with you today. Now, before we dive into the first topic of discussion, which is office romances, let's talk about some of the foundational issues. And this is important. It may be basic for some of us in the room who are employment lawyers, but as I said, this is a mixed audience, so we want to make sure that we're on the same page with respect to the basics. What is sexual harassment? There's so much going on in the media today. All these terms get just lumped together, but we should know that there are a couple of key elements. Unwelcomeness. So a lot of time has been spent on whether it was unwelcome or not, and this is really the issue when you have a consensual relationship first, and then it becomes something different. Was that really unwelcome? And sometimes it's welcome until it's unwelcome, and then also it's welcome for you but unwelcome for you, depending on who is taking the actions. Also, people misunderstand that it doesn't have to be touching necessarily to be sexual harassment, verbal or physical conduct of a sexual nature. It can be jokes. It can be completely nonverbal with postings around the office area. The other piece that is kind of confused in the media, that sexual harassment, because it's a legal term to us, when I, as an employment lawyer, hear sexual harassment, I start thinking unwelcome, severe, pervasive, these kinds of things, not just somebody is flirting with me in the office. And it has to be impacting the employment relationship. So a regular dating situation where folks are not employed with each other is not sexual harassment in the legal way that we think of sexual harassment. What is not sexual harassment? You hear Me Too, everything is under Me Too, right? Rape, sexual assault, date rape, all of these things that are outside of the employment relationship. Now, sometimes they can also touch on sexual harassment, and it's not uncommon to have sexual harassment claims that include assault and battery, where there was a touching. But most of the time, these are not the types of issues that we think of when we think of legal sexual harassment. Also, what is not sexual harassment? Some of the simple teasing. I mentioned flirting or offhand comments or even isolated incidents, unless it's severe, extremely bad, or pervasive, happening frequently. So in the 11th Circuit, where we are, there's lots of conduct that some might think would be sexual harassment, but it's really not. My favorite example is the 11th Circuit case where someone grabbed a butt and it was only one butt grab. And so it wasn't severe enough to be sexual harassment. And I should pause a second to say this. This is what we do every day, so some of it might be a little hard on the ears. Pardon us. We were just in federal court recently talking about an erection, whether or not something was an erection. So that's our everyday. So just be patient with us as we talk about these issues. Harassers and victims. Here's another common misperception that we need to get straight. As I mentioned at the outset, men can be victims of sexual harassment. Same-sex harassment is on the rise as well. And also clients, customers, those folks can sexually harass people in your workplace, and as employers, we could be held liable for not doing enough to take care of our employees when it's even people that are outside of the workplace. And finally, to kind of help set the stage, here is a slide that came from an EEOC report that was done in June of 2016, and we'll talk more about this with Daryl. But the key facts are about 60% of women experience some kind of unwanted sexual attention or sexually crude conduct in the workplace. So this is nothing new. It didn't come about when Me Too became a hashtag. It has been here. The issues have been here. Now with that, I'm going to turn it over to Carmen, who's going to talk about consensual sexual relationships.